Good evening. You're watching Brass Tacks with me, Poonam Burde, and we're coming to you live from the CNN News 18 Federal Bank Primetime Studio. Less than a week after Arvind Kejriwal secured bail, he has now received a setback from the High Court. Staying the Delhi Chief Minister's bail, the court said the trial court's order reflects perversity. A vacation bench of Justice Sudhir Kumar Jain overturned the Rouse Avenue Court's order that had come down heavily on the Enforcement Directorate. So for now, Arvind Kejriwal will stay in Tihar jail. As he dictated the order, Justice Jain said that every court is under an obligation to give sufficient opportunity to all parties involved to present their respective case. And in this particular instance, the Enforcement Directorate had contended that they were not given enough time to oppose Arvind Kejriwal's bail. Today, the court dictated its 34-page order, and these are some of the highlights of that particular order. The trial court observation that mentioned how they could not go through voluminous material that could not be considered, that is totally unjustified, said the Delhi High Court today. The Delhi High Court also said that the order of the trial court shows that it has not applied its mind to the material. It speaks specifically of Section 45 of the Money Laundering Act of the PMLA. It has not been properly discussed during this hearing by the trial courts at the High Court today. The trial court also did not deal with the argument of vicarious liability of Section 70 of the PMLA is what today the Justice of the High Court observed. Trial court shouldn't have given its finding opposite to that of the High Court is also what they said. Once the plea challenging arrest of Arvind Kejriwal was dismissed, his team cannot say that his personal liberty was curtailed, as it was an argument that Abhishek Manu Singhvi on behalf of Arvind Kejriwal made in court. That is something that does not have any legal standing, is what the court went on to say. But all's not over for Team Kejriwal. The Supreme Court is going to be hearing the matter tomorrow. The Chief Minister does have legal recourse. But in the court of public opinion and in this narrative war, has the Aam Aadmi Party lost? That's the question we ask.
ये पूरा का पूरा तथाकथित शराब घोटाला फर्जी है। भाजपा के दफ्तर में लिखा गया है। हम आज के फैसले से असहमत हैं।
Bail once granted cannot be cancelled in a routine manner.
अरविंद केजरीवाल जी के खिलाफ शराब घोटाले के पुख्ता सबूत हैं, पैसे के लेन देन के सबूत हैं, किस तरह से उन्होंने पैसा अपने निजी लिए इस्तेमाल किया इसके भी सबूत हैं।
Joining me on this broadcast, National Spokesperson of the BJP, R.P. Singh, Ashwini Dubey, Advocate of the Supreme Court, Sanjeev Srivastava, Senior Journalist, will join us shortly. Spokesperson of the Aam Aadmi Party, Anmol Panwar, will also join us shortly. But before we get into the politics, let me get the Advocate on record here. What do you make of the High Court order today? It's one order that came a few days ago, about 5 days ago, that was extremely critical of the Enforcement Directorate. Contrary to that, today's order is extremely critical of that particular order.
Of course, the superior order will prevail. The criminal jurisprudence says that the order passed by the appellate court shall prevail and will hold field. So here, the findings of learned trial court, where learned trial court has ruled by quoting the Benjamin Franklin, saying that it is better that 100 guilty persons should escape that one person should suffer. And also the beautiful phrase of Lord Chief Justice Havoc, that is, justice should not only be done but seen to be done. That has no relevance in the cases of PMLA. Here is it not the case where the ordinarily criminal jurisprudence of criminal matters under the Indian Penal Code are decided. Here, it's a special statute, and special statutes have certain conditions for bail, and the Section 45 makes it mandatory to hear the public prosecutor in all bail application, and when the prosecutor opposes the bail, the court is required to apply a twin test. And what is that? Twin test we have discussed, but the burden of proof is entirely on the jailed accused. And also, who would be often weak to fight the might of the state. But the twin conditions make it almost impossible for an accused to get bail under PMLA. Now, the other thing which has been argued is the vicarious liability. It is not necessarily to be seen that the money has been recovered. Even otherwise, if vicarious liability is there, and if ED is alleging that 45 crores have been used, that has some substance. Now, third thing is, what learned trial court has said, that it is difficult to go through the thousands of pages. So that also shows that the order of learned trial court, I'm very sorry to say, it is not to criticize Honorable Judge, but it shows that the order was passed without considering the documents available on record. Now, other thing, you remember when Mr. Kejriwal, Honorable Chief Minister, had challenged his remand and illegal arrest, alleged illegal arrest. There were two issues were framed. One, whether the arrest of Mr. Kejriwal is illegal and arbitrary, and whether the arrest by order date on 21st March 2024 and consequent remand, it contrary to Supreme Court judgment, that matter is pending in the Supreme Court. And the second issue was whether he is entitled to be released from custody in view of his arrest and remand order being illegal. That order is also pending. So here, if we see the criminal procedure code, if we see the other provisions of the code and the hierarchy of the courts, the superior order will prevail. Honorable High Court has passed that order, overturning the trial court's judgment. Let's see what will happen tomorrow in Supreme Court. That would prevail. If Supreme Court grants him bail, then today's order will be overlooked, overturned. Yes, over to you.
Right. Anmol Panwar, why does the Aam Aadmi Party today think that this order is biased? You welcome the order that came from the Rouse Avenue Court a few days ago. Why do you think this one is biased?
Mr. Dubey spoke a lot about the established procedures of law. Mr. Dubey might be aware of the fact that Article 21 of the Indian Constitution guarantees the right to life and personal liberty, and no person shall be deprived of his life or personal liberty except according to the procedure established by law. Mr. Dubey, please inform the viewers whether it has happened even once in the history that even before issuance of a formal order by a sessions court, the High Court grants an interim stay. I don't think so, and this marks as an unprecedented departure from the established judicial process. I mean, we have never heard of such thing in the past. I am also a practicing advocate since last 10 years, but even before the sessions court passed an order, the High Court granted an interim stay. And the observations made by the Honorable Supreme Court day before yesterday was that it is an unusual practice that an order has been reserved on a stay application for 2 days. I would like you to enlighten the viewers on this.
But you speak of personal liberty. That's something that today the court had also spoken of. They also went on to say today that because his plea challenging his arrest was dismissed and his arrest was deemed legal, there is no question of personal liberty being curtailed.
Not at all. His arrest has not been deemed legal. The matter is sub judice before the Honorable Supreme Court. The arrest of Mr. Kejriwal is illegal and unconstitutional. It is a fabricated case in an attempt to crush the Aam Aadmi Party. Very serious observations were made by the trial court going through all the records. Ample opportunities and time were given to the
They didn't go
advocate
through
of
all the
Enforcement
records.
Directorate.
That's what
They-
the order went on
let
to
me-
say, that we did not
let
have
me-
time to go through all of the
No,
documents that were
not
put on
at all.
record, which is
let
something
me
that was
read-
taken objection to by the High Court today.
Let me read para 16. It says that although various bulky documents and citations have been filed by both the parties, most of which were not even relevant in the aspect of the present case, it has very specifically been mentioned in the order. And the Honorable Sessions Court said that ED is acting with bias. There's no trace of proceeds of money. Since last 2 years, not a single penny has been recovered by the
Sure,
Enforcement
but you were
Directorate.
quoting from the
And
Rouse
this
Avenue.
investigation.
Sure, Mr.
and this
Panwar, you were quoting from the Rouse Avenue Court order. So let me quote from there. It says that it's not possible to go through these thousands of pages of documents at this juncture, but this is the duty of the court to work upon the matter which comes for consideration as per the law. Sometimes courts refrain from passing such orders on account of various reasons which may have long-lasting effects. The fact that that judge said that there wasn't enough time to go through all of this material was something that the High Court today spoke of, that is completely unjustified. Then you shouldn't have passed an order if you didn't have time to go through all of those records, is what the High Court said today. It's not me who's saying it.
What is completely unjustified is that the High Court, even without looking at the order passed by the trial court, the appeal was filed without that order, which has been challenged before the High Court. And then an interim stay has been granted. The ED approached the High Court at 10:15. Order was passed at 11 a.m. and the interim stay was granted at 10:30 a.m. On which order have they granted interim stay? I mean, if Mr. Ashwani Dubey can enlighten the viewers as to which rule or which procedure says that an interim order can be stayed without even a concrete order in place without
Sure. So
formal
this question
issuance of that
this
order.
question is specifically
And
to
the
Ashwini
TD
Dubey, so I'll give him 30 seconds to respond before I get in the other two gentlemen as well. Ashwini Dubey, what was the haste for the High Court to even stay it before the trial court's complete order was out? That's a question the Aam Aadmi Party has been asking since that day.
It's
That
not
is
the Aam
very
Aadmi
well-
Party. Everyone in the country is asking this question.
Sure. And the Aam Aadmi Party, let's say, is speaking on behalf of the rest of the country. So here I would like to say the Aam Aadmi Party is saying it. But sure, Ashwini Dubey, go ahead.
High Court is the constitutional court. This is within the wisdom, this is within the discretion, and looking into the various aspects. Also, the questions which have been decided by Honorable Justice Swarnakanta Mehra while rejecting the remand challenge.
Sir,
which is
please
under
tell the rule
Supreme-
or procedure,
Now,
sir.
You've asked the
Now-
question, sir. Let him answer, please. Give him 30 seconds at least to respond.
Now, tomorrow, the Honorable Supreme Court, if enlightened that Honorable High Court was wrong, then Honorable Supreme Court would overturn it. But the question here is not this. This is, I again say, the High Court is a constitutional court. You remember the Tista Seetal Ward's case, there was no even paper filed before the Honorable Supreme Court, but bail was granted. You remember the recently the 3 judges bench set. So it is within the domain. It is within the discretion. It is within the wisdom. Certainly, if it would have been a case where learned trial court would have exercised jurisdiction, that does not cease to exist with the learned trial court. But so far it comes to the High Court and the Supreme Court. They are the court of constitution. They are the constitutional court, number one. Number two, if it is a case that there was no order, the Honorable Supreme Court will hear it tomorrow. Supreme Court will certainly pass any precedent or judgment which will be followed in future. But here it is between the order is between two courts. We are nowhere to say कि कौन सी court का कौन सा jurisdiction, but it is very well within the jurisdiction of the Honorable High Court. That is why yesterday Honorable Supreme Court did not intervene. ये court order है. So let us see.
I need 10 seconds to respond. I need 10 seconds.
Yes, Mr.
Mr.
Panwar, go ahead. 10
Mr.
seconds.
Dubey, the courts operate under a strict set of procedures which are designed to ensure transparency, fairness, and the rule of law. They are not akin to khap panchayats which may function without rigid adherence to legal standards. You must admit that. And secondly, the Honorable Supreme Court even said that we will not commit the same mistake which the High Court has committed. These were the observations by the Honorable Supreme Court. Even they admitted that without issuance of order, an interim stay cannot be granted.
Sure. So RP Singh, there is some sort of haste that was shown to stay this order by this particular court. The High Court is biased, says the Aam Aadmi Party. There is absolutely no proof as far as any links of this excise policy alleged scandal to Kejriwal is concerned. This is what the Rouse Avenue Court had said last week. That is something that the Aam Aadmi Party reiterates today and says this is us being vindicated, despite whatever the order from the High Court today is.
Well, as per Aam Aadmi Party, Poonam, the High Court is a khap panchayat. He just now said that it's like a khap panchayat.
We have not
You
said
can't
that.
run
I
like a
have
court
not.
like a
Please
khap
do
panchayat.
not
No, he
misquote.
did, sir.
Please do not
RP Singh, he
misquote.
said it's
I
not.
didn't
That
say
there
that.
are said laws and procedures that it is governed by, and it's not a khap panchayat, which is why certain rules need to be adhered to, is the point that he was trying to make. But anyway, go ahead.
So, as per him, High Court is not adhering to rules and regulations. They are
So
working like a khap
please,
panchayat. Okay,
you
restate
enlighten the viewers as to under which rule has that order been stayed. आप बता
Anmol
दीजिए
Panwar,
ना,
it's
Poonam,
been
Poonam,
Anmol
who's
Panwar.
running
He's
the debate?
just
You or
started
Mr.
speaking.
Anmol? I mean-
Anmol Panwar, he's just started speaking. Give him some time to make his point. I will come back to you. I'll give you enough time to rebut. But let's not speak over each other. Let's try to keep this civil. RP Singh, go ahead.
I'll appreciate you'll ask Mr. Pawar to behave like a good lawyer, not like a Aam Aadmi Party spokesperson who are generally anarchists and who heckle other people who come on debate. I mean,
So you
I
don't
never
have
heckled, I never
anything to
spoke a
say.
word when
You
he
don't
was
have
saying whatever he
anything
had
to
to
say.
say.
That's why rather than speaking
Okay,
on the
let's not
merits
get
of the case,
let's not get
you
personal,
just-
gentlemen. Let's just stick to the point, please. RP Singh, I request you to stick to the point as well. I understand it's been 12 minutes into this debate. We've just gone to the other gentlemen. Sanjeev Srivastava is patiently waiting as well. So Anmol Panwar, I would really request you to not try and heckle any of them, to not speak over them. I will give you your time enough to rebut each and every one of them. But RP Singh, yes, go ahead.
Well, one thing which happened in the lower court was that lower court didn't appreciate it that this is a PMLA case. This is not a routine matter, and there are certain different laws and bylaws for PMLA case, and it has to be dealt differently. Here, the onus of honesty or honest of not being guilty is on the person who is answerable for it. And also, what did the High Court said today? The High Court Justice Sudhir Jain said malified intention on the part of ED was incorrect. He has overturned the order of the lower court where he has said that malified intention on the part of ED was incorrect. Secondly, he also said that the vacation judge has not provided the Enforcement Directorate sufficient opportunity to present their case. The primary petition allegations required meticulous consideration by court. This is not me, this is the Honorable Justice of the High Court is saying. He further, let me take it further. The court noted the trial court order had inadequately discussed the mandatory condition, had inadequately discussed the mandatory condition under the PMLA. That's what I was saying. Mr. Pawar is trying to make it a common case. कोई सड़क छाप, कोई गुंडा, कोई चोरी चकारी करता पकड़ा का, गाड़ी चोरी करता पकड़ा का. This is a case of a money laundering. This is a case of swindling money in a blue collar system.
इस तरह का केस है आपका. Even a pickpocket cannot be arrested with the kind of charges you have given.
Why you get hecklers on debate, ma'am? Poonam, why you get hecklers on debate?
So
did I heckle him? I mean, if I start heckling him, he won't be able to utter a word.
Panwar, I asked you to
just
keep
spending
this.
time.
I asked you to keep this civil. I will give you your time. Let him finish his point. He's just about spoken now. Let him finish his point. I'll come to you. RP Singh, 30 seconds.
Well, I have nothing else to say. You allow the heckler to say what he has to say because they can't, I mean, they are anarchists. They have never learned the law of land. That's what they did. They came to power. They started looting Delhi. They started using the power of Delhi, Delhiite gave them to do scams and then use that money for the election. I'll give you one example out of this context. The gentleman named Rajinder Singh Solanki, who was caught red-handed with 20 lakh rupees in Gujarat, in Bardoloi. There was a driver with him. He said, "Ki mera paisa nahi hai, that's not my money." This is a driver who is a conduit, who's a conduit between the center party and the state party, and he does it every now and then. He uses my car, he is being put on my car, and there's a case going on, registered case going on. Please Google and search. There's a case going on, this case. It's the same thing. Only thing is, it's matter of time that ED has already produced details in the court. When the trials start happening, ED will give all details. How did the money transferred? Who were the people involved? There are records on. Give me a second. I'll name now. I have to name the people who have given statement under Section 164, saying that yes, they were the one who transferred money, which was given by the people who are related to Aam Aadmi Party. And give the name of the people: Ashok Patel, Kiran Bhai Patel, Jagdish Sharma, Ashok Chandu Bhai, Mr. Kirat Ambalal. And they have given all evidence on under Section 164. They put this on record under Section 164, where they can't, it's not in the police station, it's in the front of the court. Now, all such people have put it on record that it's almost into 45 crore rupees which was transferred, and ED has all the records, and ED has produced a record in front of the High Court. Now they are moving to the Supreme Court. Let's see what the Supreme Court will say on that. But we have to accept that High Court has turned down whatever was being said or whatever was being transpired in the Rouse Avenue Court by a vacation judge, who was not a regular judge, and then he heard the petition as a regular case, not as a PMLA case.
It shouldn't have contradicted the High Court's earlier order as well as what the High Court observed today. But Sanjeev Srivastava, is this a selective way of looking at how the judiciary functions? If an order is in someone's favor, then let's all claim vindication and let's all say, oh my God, what a great order. But if it's not, then aspersions are cast on the judge on whether it was biased and not biased, why there was haste, and all of these questions are asked.
See, Poonam, unfortunately our politics has come to such a pass that the trial court judgment was being commented upon by just about everybody who is against our party or Arvind Kejriwal. And similarly now the High Court judgment is being commented upon and is being seen in different kind of ways by people who are sympathetic to Kejriwal. I think this matter is very simple. A trial court took a stand, gave out a judgment, granted bail, and that was stayed, and the decision has been overturned by High Court. Now there is an established hierarchy, there is established practice, and now the AAP party is free to go to the Supreme Court, argue their case, and I think the matter will rest there. So this is, after a point, it's a political debate really. It's not a it's not a legal issue. On the issue of legality, while I am not a lawyer, at the same time I also understand the points which the lawyer, Mr. Anmol is his name?
Yes.
Who is representing our party or is sympathetic to their case. I also appreciate and understand the point which RP Singh is making, and also the other lawyer, because both, that's the beauty of law. You can argue both sides, take different points of view, but ultimately the judge's decision is supreme. You can only argue against it or challenge it in a higher court, and that's what our party is going to do. And finally the Supreme Court will come out with a decision. Whether they will grant bail, not grant bail, uphold the High Court's order is anybody's guess. Abhishek Manu Singhvi, who is appearing on behalf of Arvind Kejriwal and Aam Aadmi Party, is one of the best lawyers in the country. I am sure he is going to put a great case forward, and so will the government side. I really have no clue what the Supreme Court will decide. But this is just the way our politics has become. Everything is challenged, criticized, because politics has become so personal. And the only one thing which I'll say, I don't know the merits of this case, which side is right or wrong, but the last few years politics has moved in a certain direction which does smack of vindictiveness, because while RP Singh is absolutely right that this is a PMLA case and certain different sets of laws apply and the onus of proof is on the accused and bail is not a natural right of the accused, which otherwise is. What really begs the question is, why was such a law made in the first place? Because this law is also recent, amendment is also recent, but that's neither here or there. The final thing is, the trial court said something that has been overturned by High Court. Let's wait for the final judgment by the Supreme Court or decision by them.
RP Singh, this is what many within the opposition have said time and again. The kind of action or the alacrity that is being shown by the Enforcement Directorate or by other investigating agencies is only in case where they are probing leaders of the opposition. That same sort of alacrity is not shown when leaders of the BJP or the BJP allies are being investigated. That's where the whole vindictiveness allegation comes from.
Poonam, I'll answer that, but I have to make a small point for on what Sanjeev said. Sanjeev said that the law was brought by the ruling party. No, sir, law was brought by the UPA and then further strengthened by BJP, NDA and Parliament, sorry. And then later on, all political parties went to the court and they were their ground was turned on. Now it is under review. The review petition is filed. Let's see what the court has to say under the review petition. But initially, court has turned it down, saying that no, law is good, and then we don't want to turn the law. But coming to the coming to your point that the opposition is being targeted or no one is being spared. The cases are generally PMLA cases are blue-collar cases where blue-collar crime happens. People who are smart enough to use tricks of the law or loopholes of the law to their advantage and circulate money in such a fashion to their advantage, and then rotate money in fashion which comes to their advantage. So it takes time. Every case takes time. There is a case which was filed against Mr. Rahul Gandhi and Sonia Gandhi in 2012, which is still on. That case is still on, and then probably it will take some more few years because the judicial process is such that it takes time. Even in Mr. Kejriwal's case, he didn't turn up for the hearing. He didn't turn up to the ED on the almost 9 or 10 times when the notice was sent to him. So he took his own time because as per law he took advantage. It took almost a year or 8 months to appear in front of the ED, or sorry, ED then probably came and picked him up. But that's how the complete legal procedure is. It takes time, and it's nothing. And again, I reiterate, no one will be spared. If you feel that anyone is being spared, Mr. Anmol Pawar is a good lawyer, and then they have already hired one of the best lawyers in the country on the expense of Delhiites, not on the expense of the Aam Aadmi Party, and they can use his services to pursue the cases.
Mr. Anmol Panwar, several questions are being raised as far as the Aam Aadmi Party's conduct is concerned, but as far as this particular case goes, like Sanjeev Srivastava was saying, it is as much about the legality, but it's also about the politics. It's also about the optics and the narrative war really that seems to be going on. Where do you think then the Aam Aadmi Party, or what do you think the Aam Aadmi Party is left with as far as that aspect is concerned? Because many would say that you've lost as far as the court of public opinion is concerned. And that goes on to show in the recently concluded Lok Sabha elections. The kind of sympathy or support that you expected from the voter, you didn't get.
Puramji, what do you expect from a party whose leader was put behind bars just days after the Model Code of Conduct stepped in? He was put behind bars on 21st of March. And the reason why he was illegally and unconstitutionally put behind bars was because Bharatiya Janata Party was afraid of him. They did not want him to campaign in the elections. But the people of Delhi are intelligent enough. They very well know
he campaigned.
That, sir, please do not interrupt.
Sure, he may not have campaigned as much as the Aam Aadmi Party would have liked, but sure, he did get some time towards the fag end of the campaign to campaign. But
Poonamji,
yes,
the observations made by the court demolished the case of Enforcement Directorate. They tore apart the arguments made by ED's advocate that no money trail has been found.
Which court?
Not a single penny has been recovered even
Which
after
court?
2 years
this was the
of
Rouse Avenue court,
investigation.
sir.
Which court?
This was the Rouse Avenue court which gave its order last week. Yes, Mr. Panwar, go ahead. RP Singh, I'll come back to you.
Yeah, not a single penny has been recovered. No money trail has been found. They have failed to trace the proceeds of money to Mr. Kejriwal. And the fact is that ED is acting with bias. This is what the court said. And he's not even named in the ECIR of the Enforcement Directorate or the FIR of the CBI, even after 2 years. This speaks volume about the baseless allegations made by the Enforcement Directorate. They have failed to prove it. And very important point, what the advocate of Enforcement Directorate said in the court. It is mentioned in para 28. He said that because they don't have any evidence, that's why approval came into scene. He said that investigation is an art and sometimes one accused is given a lollipop of bail and pardon and induced with some assurance to make them tell the story behind the offense. The 4 approvers on the basis of which their entire case is relied upon. One of the approvers is P. Sharad Reddy, who gave 60 crore bribe to Bharatiya Janata Party, and then the Enforcement Directorate did not.
That's the allegation that was a bribe. There is no proof of that either. If we're talking about
the
innocent until proven guilty, then that yardstick should be applied on both sides, isn't it?
The turn of events very clearly indicate that he gave the bribe on 10th of February, and thereafter the Enforcement Directorate did not oppose his bail application. The other was their alliance partner, Maguntha Reddy, who contested from TDP, and Mr. Modi campaigned for him.
Sure, and whether any of these approvers and their testimonies have any legal standing is something that now the Supreme Court will also look into. All of this will be looked into when the merits of the case are looked into, and tomorrow the Supreme Court will look at that. But while you quote the Rouse Avenue Court's order, why not also quote today's order is what I have been asking you since the start of this show. When you speak of how the Rouse Avenue Court said that the Enforcement Directorate's intent was malified and that they were biased, today the High Court has gone on to say exactly opposite of that. They said there is absolutely no evidence that there was any malified intent from the ED side.
See, I've stated it initially as well that this order was passed even without the formal issuance of the order by the Sessions Court. So that itself indicates.
Not at all.
Sir.
Not at all.
Please do not mislead, sir. Do not mislead.
No, not at all. You are spreading lies. I mean, you're telling
the
that.
Country knows. We are not.
No. You are. No. Your word is not the gospel truth.
Your word is
not the gospel truth.
Sir.
अरे चोरों की बारात हो तुम लोग तुम्हारा नेता से लेकर तुम्हारे सब बाकी सब लोग सबके सब लोग चोर हैं समझे नहीं तुम चोरों की बारात हो
We're talking about the merits of this case and what happened as far as the Rouse Avenue court.
अरे चुप चोरों की बारात का हिस्सेदार
RP Singh and Anmol Panwar, I request you all to please keep this civil. Let's not get into name calling. which court order is looked at, that may be selective. To each its own. Everyone has the right to do so.
Now you are giving lectures on morality and corruption.
Mr. Panwar, the same argument may be made against you as well. The action that you claim is vindictiveness is the same accusation you've been accused of doing in Punjab. So let's not get into that. That's another debate altogether. But I want to give in the last word to Ashwini Dubey and Sanjeev Srivastava on this as well. Ashwini Dubey, as far as legality is concerned, we're talking about how selectively one may see certain judgments. And fair enough, it's their right to do so. They have legal recourse. The Aam Aadmi Party has gone to the higher court, and if the Supreme Court decides to overturn what the High Court did, then that would supersede what the High Court says. But this is a serious allegation, a serious case that we're talking about. Why make it political? Why cast aspersions on political affiliations of the judge or the haste or the lack of wisdom of any judge?
This judgment should be criticized, or legally it should be challenged instead of criticizing the judges. One judge, one court. It has become a fashion now to selectively target the judges. It has become a fashion now to selectively target the judgments which are in favor. All right, justice has prevailed. And if that judgment is passed on the basis of considering there are material evidence against the accused, nahi sir. Bilkul, this is a very bad precedent which has started. See, what I have read as a student of law, that the Superior Court's order prevails. Superior Court's order would hold the field. And since the High Court has today have already ruled that entire voluminous record which was not perused by the learned trial court is totally unwarranted and showed that the trial court has not applied its mind to the material. Honorable High Court has also accepted that there was no proper opportunity. Why we can't discuss it? One. Number two, I would also like to read certain paragraphs, or I would like to just remind my brother Anmol, he's taking very personal, I understand. But I'm just, what a student of law I should say, I will say, Honorable Justice Swarnakanta Mehra in the previous round of litigation have categorically said that the political party, being the head of the political party, he is answerable. Also, 9 times summons were issued. He did not appear.
Right.
Issues were framed. So we should also discuss that. If tomorrow Supreme Court
sure,
passes
and tomorrow when
order,
Supreme Court comes out with
the
order, all
order
of that
will
will be
challenge
discussed
before
again, and
Supreme
we'll
Court.
definitely have another version of this debate when the Supreme Court order does come out tomorrow, irrespective of which way it goes. Unfortunately, I'm completely out of time. I have to thank you, gentlemen, for joining us here on this broadcast.